certainly experience to date has been that it can be prejudicial, it can be biased, and that's because it has relied on a history of often human decisions or human outcomes that were infected by bias or historical disadvantage. So that's how it can be prejudiced, in that AI at the moment tends to be looking back at historical data. So most data has to be historical because it's in existence, rather than looking at forward socially preferred or non-biased and non-prejudicial outcomes, which humans tend to be still good at in making a conscious decision not to be biased. I can't see a day where it will be accepted as being the only way to do it, but I could see a day where in certain situations it could be a preferred way of doing it. The response that we had from human resource management professionals indicated that it is a task that humans are good at and appropriate to undertake, because it requires a good understanding of those frontal lobe emotions that people go through during those conversations. But there are also aspects where it is difficult for a human listening to it to remain impartial and not connected in some way to the personal difficulty of the person being made redundant or terminated for other reasons. And that's where an artificial intelligence or computer generated conversation could actually keep the process calm, on track and consistent. Yes, they can, but if they do, they need to establish that they're doing so in a way that is reasonably necessary to protect some lawful interest of theirs. So the ordinary rule is you should seek consent, and it would be consistent with trust and confidence that you'd expect in employment to have an agreement on it. But if, for example, this employee believes that their personal interests are being affected by an outcome that they may need to assert in legal correspondence or in proceedings, that's where they may be able to argue an exception to the usual rule about not conducting a covert or secret listening devices recording. Yeah, they should, and it's easy to do, either simply with having your smartphone already switched on to record before entering the meeting, or some people might be aware that one of the latest updates to the Apple iOS allows you to leave a device concealed and use your in-ear earphones to record a conversation, which could be happening after the meeting. So the employee's left the phone under a piece of paper and they're using their in-ear earphones to listen in on what's being said after that discussion, which could be something that's the employer believes is prejudicial to their interests. I'd be surprised if there aren't workplaces already doing it. Certainly it's been documented in foreign jurisdictions such as China. There are already software development companies that use facial recognition as a automated Bundy clock system. So when employees turn up in the morning, there's a facial recognition snap taken of them clocking in, and when they leave in the evening, their face is recorded again. That's the Bundy off. So there are payroll systems that do offer that sort of biometric recording. Whether or not it should be done, or if it's counterproductive in the sense of employee sentiment that this is personal data that is being collected from them for a purpose that may not be fully understood, it raises genuine concerns about, well, is this data safe? Is it being stored securely? Is it susceptible to being obtained or maliciously retrieved by third parties in a way that could be used to the detriment of the employee or the business?